Hello and welcome to the Kenneth Verkammer Law Office Legal Podcast, looking at recent criminal and DWI cases. And this edition, we look at the New Jersey Supreme Court's decision in State versus Chun, which we call some of State versus Chun 2, decided in 2013. The court basically held the failure by the state police to create and maintain a centralized state database is not a violation of the Supreme Court's 2008 Chun Order. Now, by way of background, the Supreme Court on March 17, 2008 issued its unanimous opinion addressing the challenges raised by the defendants to the scientific reliability of the Alcotest 7110 machine. In 2013, the defendants moved for an order in aid of litigants' rights, contending the state had failed to comply with the court's 2008 order, principally by failing to create and maintain a centralized statewide database, and asserting more specifically that the database that was set up lacked integrity because it differs from the manner in which data was previously stored on and available on CD-ROM, and it was incomplete as to certain types of files and cycles, and was presented in a format different from the one noted in the report of the special master, and also was subject to a third-party software developer's fee. The defendants therefore requested that the Supreme Court deem the state to have violated the 2008 order, and that the Supreme Court direct the state to redesign the database to comply with the defendants' understanding of the meaning intent of the court's 2008 order, and that the Supreme Court direct the state to ensure the integrity of the data in the database and for other relief. The defendants here were struck down, or the words was their relief was denied. The Attorney General's office responded to the factual assertions concerning the integrity and operation of the centralized statewide database raised by defendants through affidavits of Dr. Baum of the Office of Forensic Scientists and another research scientist who had the oversight for monitoring the Alcotest data and database integrity. The state police, and through the Attorney General's office, therefore filed their own motion for litigants' rights, requesting that they no longer be required to comply with portions of that 2008 order by the Supreme Court. Let's say, and they requested to be continued to use old software. The Attorney General's office requested that the state be relieved of its obligation to comply with the court's order, based on the fact that the old database was unusable and unworkable. The Attorney General's office represented to the Supreme Court that Draeger, the manufacturer of the machine, had advised that the Alcotest will no longer be serviceable after 2016, and the state is now in the process of evaluating alternative breath testing devices for implementation. The defendants also moved for an order requesting that the software changes be made forthwith, and otherwise the Alcotest should be deemed unsuitable for New Jersey and should not be used. The defendants challenged things such as fuel drift algorithm, but the Supreme Court rejected most of the defendants' contentions, and the Supreme Court concluded that the centralized statewide database was in compliance with the court's 2008 order. The Supreme Court also held that the defendants have failed to demonstrate that the state has willfully refused to comply with the Supreme Court's order. And they believe that the state had demonstrated that, in spite of its best efforts, it did not have the ability to comply with certain portions of the order, based upon the fact that the Alcotest was going to be phased out by Draeger. The Supreme Court concluded that the software being used was sufficient and basically scientifically reliable, and the results of an Alcotest were admissible in DWI cases. There was some reference that there had to be changes for women over 60, but unfortunately for defendants charged with DWI, the Supreme Court held that currently the machine could be used. For representation in DWI refusal and criminal municipal court cases, contact the law office of Kenneth Verkammer at 732-572-0500. Also visit our website at njlaws.com and benotguilty.com. That's benotguilty.com. Thank you.